Welcome, everyone. My name is Josh, and I will be your moderator. I'm excited to welcome Ali Oromchian as our speaker tonight. Ali is the co-founder and chief executive officer of HR for Health, which is a software-as-a-service platform that provides web-based human resource solutions and advice for healthcare practice owners and managers. Ali is also a founding attorney of the Dental and Medical Council law firm and one of the nation's leading legal authorities on topics relevant to doctors. Before we get started, I would like to point out that CE is not available for this webinar. Ali, welcome, and thank you for being with us tonight. I will pass it over to you now.
Awesome. Thank you, Josh. Thank you. And I have to tell everyone that I almost didn't make this webinar because I tweaked my back so badly a couple of hours ago that I had to actually take a muscle relaxant to be able to even sit in this chair to do this. So, you know, not all heroes wear capes, people. Not all heroes wear capes. But joking aside, if you see me grimace, it's not because of anything other than, you know, I think I just tweaked a really bad muscle. But anyhow, I can't even believe I'm doing a mid-year update for 2023, considering it just feels like 2023 just rolled around, and yet, you know, here we are. We're doing a mid-year update. Kids are mostly back in school. For most of you, you're getting back into the grind of kids being in school and you having to get back to your normal schedules. And so it was a great time to kind of go through things that have happened in 2023, updates that have occurred that you may or may not be aware of around the country. And then two, having strategies leading to the final, few months of the year as you prepare for 2024. So let's just jump right into it. We're going to hit on a couple of big items. First is we're going to talk a lot about the minimum wage updates that occurred around the country at the federal, state, and local level. Huge importance on a variety of reasons, which I'll talk about. We're going to talk about wage and hour or rules that have changed, leave laws that have changed around the country. So some major changes have occurred, in 2023. So we're going to go through that, and then we'll talk about how to prep for the end of the year as you get ready for 2024. So for those of you that don't know me, as Josh mentioned, I'm a dental attorney, and this is all I do. I help doctors and dentists around the country, start their practices, sell their practices, get into partnerships, lease negotiations, of course, manage their employees, hiring and firing and everything else. And as he mentioned a few years ago, we created a software called HR for Health that helps you navigate all of the HR complexities of a dental practice, whether you have 3, 4, 5 employees or you are a group with 30, 40, 50 employees. The software is designed for you to ensure that you have complete compliance in your office. And that's a lot of the things we're going to talk about today have to do with, obviously, HR compliance and how to make sure you're safe. My wife is a pediatric dentist in California. And so a lot of the rules that we're going to go through today apply to her just as it applies to you. And so dentistry is very near and dear to my heart, and I live your life through her. And so please feel free, when you get my contact information at the end, to send me questions and whatnot. I'm happy always to answer these because some of these can be very complex. All right, so let's jump into it. What are we going to talk about first? The first section is we're going to talk about minimum wage updates and then some onboarding and hiring changes. Now, you might say, well, why are minimum wage rules so important to me? I pay way more than minimum wage, and I have, a P&L to show for it. And that is true. And many of you probably are above minimum wage rules. But as I have seen in this year, and it's been more than, a handful of clients who have not updated, minimum wage salaries or wages for their employees, despite the changes that have occurred to, at the federal, state, and local levels. And so that has gotten them in trouble. Also, for those of you who have exempt employees, it's very important for you to know what these minimum wage rules are, because, as you know, you have to pay your exempt employees at least double minimum wage for them to still qualify to be exempt. So these things really make a difference. So what are the rules, right? Because there's a lot of misinformation out there, and we see it sometimes. Articles being published by others who kind of speak in generalities and don't really focus on your practice and where you are, and so you may take this information and run with it, and unfortunately may not be correct. So I'm going to go through this with you. So the federal minimum wage law, okay, applies to the entire country. Okay, and that is, it went up from $6.55 to $7.25. Okay, that is the federal rule. Now, the states can have their own rules that cannot be less than $7.25, but they can set their own minimum wage rates that are usually higher than that. And so you have to, make sure that you obviously know the federal number, it's $7.55, but that's the bottom. So then you have to check your state rate. What is it in your state? Because that applies. Then, right, and this is a mistake that also happens frequently, is you have to check your local, locality, right? You have to check your city, your county to see, does your city or county have its own minimum wage rules that are different than the states and different than the federal government. So there's multiple layers of this. So many of you who rely on, traditional, payroll companies, and you don't really have an HR system like HR for Health to help you, if you're relying on just a payroll company, you have to remember you're signing documents when you sign up with them that basically makes it your responsibility to ensure that your employees are paid correctly. So we've had a high number of cases being filed by employees against our doctors because the minimum wage rules changed in January, right? It went up 50 cents in some states, 25 cents in other states. It just changed. And the doctor hadn't changed it in the payroll system because they didn't know about it, right? And the payroll company, of course, they should be letting you know that you're paying people unlawfully below minimum wage, but of course they don't care, so they don't look at it, right? This is one of the many reasons why, whether you have 3, 4, 5 employees or you have a lot, you need an HR system on top of just payroll, okay? So make sure you check your state and local numbers. Now, the highest minimum wage is $17 an hour. It's $17 an hour, and it's not in a state that you might suspect. It's not New York, it's not California, Washington, Illinois. It's actually Washington, D.C. And it's not something that you would normally think of as a state with, or a district having such high minimum wage rules. But this is what I mean by just make sure that you are looking at your state and local levels. If you are confused by it all and you want help, just reach out to HR for Health and we will get you this information. So just to give you a little bit more detailed information, there are 28 states and the District of Columbia that have changed their minimum wage laws since 2014. Okay, so since 2014, these rules have changed in 28 states, including the district. The effective minimum wage has increased in 30 states and the District of Columbia. Okay, so that is important for you to know. 48 localities, right? These are cities, counties, have adopted minimum wages that are above their state minimum wage. Okay, so 48 around the country have rules that are different than their states. Hugely important. Okay, and then there are 30 states, including the District of Columbia, that have minimum wages rules that are higher than the federal government's minimum wage. Okay, so just kind of keep this in mind because many of you will fall into one of these states that we're talking about. Okay, now there are 8 states that have absolutely no minimum wage laws, and so the federal rules apply to them. Those are Alabama, Georgia, Louisiana, Mississippi, South Carolina, Tennessee, and Wyoming. We expect some of that to change in this coming year, so just kind of keep that in mind. But again, remember, it's easy to ignore because it's not something that we all think about. But if your state is suddenly at $15, $16, $17 an hour, you could easily be violating these rules for some of your employees. All right, let's shift gears a little bit to EVerify Laws and specifically what's happened in Florida. So in Florida, as of July 1st of 2023, so this just happened last month, Florida requires all private employers with 25 or more employees to use the federal EVerify system to verify if an employee is entitled and is eligible to be an employee in the United States by looking into their I-9s or whatnot. So you might say, well, what is EVerify? I've never heard of it. Well, EVerify has historically been for the largest companies in the country who must use this system that the federal government has set aside, which is an internet-based system created by the Department of Homeland Security to verify employment eligibility information by the employer. Okay, so they take information and they take it from federal databases, they take it from which means like social security numbers and other things, and they try to verify it with the information that you're providing them. It's a way to supplement. It doesn't replace the I-9 verification forms. Okay, that doesn't replace that, but it's a way of supplementing that verification. Okay, so it's an extra step that now in Florida, you must do. Now there are some other states that require EVerify. Florida is just the one that went active in 2023, but those states include Alabama, Arizona, Georgia, Massachusetts, Mississippi, North Carolina, South Carolina, Tennessee, and Utah, right? And Utah. Now, each of those states have a slightly different rule regarding how many, which employers must use the EVerify system. So if you have any questions about it, just reach out to HR for Health, and one of our team members will give you that information. But as of right now, Florida has enacted this. We do expect this EVerify system to kind of spread around the country. And so like most laws, these kinds of things do expand. And so most of the country will probably be required to use EVerify at some point in this decade. But how soon or whatnot, we don't know. All right, in New York City, for those that are in New York City, there's been limitations as of July 5th, and we talked about this in January, that it was coming, that you cannot use automated employment decision tools in hiring. And if you do, then it has to go through a certain audit to make sure that it's not biased. Okay, now there's penalties for violating this. It's like $500 for the first violation, $1,500, for everyone after that. But you might even ask, well, what is an automated employment decision tool? Well, an automated employment decision tool, in essence, is some sort of computer based tool that uses machine learning or artificial intelligence, statistical modeling, data analytics, to help make decisions about whether you should hire someone. Okay, whether you should hire someone. Now, there are a lot of different models of this, right? So there's a lot of different types. So it can be things that are using artificial intelligence to look for keywords, right? So it may review a resume and look for certain keywords, like Dentrix, or whatnot, and see, okay, if it doesn't have Dentrix, reject that applicant, for example. Those kinds of things are the things that are no longer allowed in New York City. Now, some of you may be using some of these recruitment tools online, for job posts and whatnot. Some of these recruitment tools have these kinds of things incorporated in them where, you have to set certain parameters. So you have to be very careful about using those if you are in New York City. There is talk around the country of, making these rules, valid in different states. But right now it's only in New York City, and so it's probably going to take a little bit more time before it does that. All right, now kind of switching gears again. As you know, there's this trend occurring where you have to put your pay range in the job post. And so California, Colorado, Connecticut, Maryland, and Nevada already have these rules, depending on what size employer you have. Albany County in New York now also requires these job posts, so just kind of keep that in mind. Now you can make your life a lot easier by using our software, because we have specific job descriptions in the software that's been drafted for you. And you can put those, pay ranges in there and just copy and paste into any job post, and then off you go. So very, very easy, very, very easy to use, especially if you're using our job descriptions that we've created. All right, now let's switch gears a little bit to something that a lot of you have heard about, which is there are restrictions that are being passed at the federal level and at the state level regarding non-competes and non-solicitations. Many of you have hired us to help draft employment agreements or independent contractor agreements that protect your intellectual property. It's a big part of what we do. We draft contracts for associate dentists and others that prevent them from stealing your patients, stealing your staff, stealing your technologies, business strategies, marketing strategies, those kind of things. But these kinds of rules are coming under a lot of pressure because there's also typically tied to those, there's restrictions on competing against you and whatnot. Some states like California, it's totally illegal. Other states like Georgia, anything goes. But there is a shift happening now. In January of this year, the FTC, the Federal Trade Commission, proposed a new rule that made imposing non-compete on workers with very limited exceptions absolutely unlawful, right? Absolutely unlawful. And there was a ton of penalties and stuff attached to it if you violated this. And this applied, by the way, not to just employees, but also to independent contractors and really anyone who works for you, even if they're even if they're unpaid, like an intern or whatnot, which is kind of silly, but it is part of it. They have also put in requirements in their proposed rule that if you do have non-competes in your contracts now, you would have to notify the employee that those are no longer valid and maybe give a new contract or whatnot. Now, this vote, was supposed to happen in 2023. It's been delayed into 2024 so they could get even more information and feedback or whatnot. But what we are seeing as a result of that is that a lot of states are starting to kind of have their own rules. And Indiana has a rule for physicians whereby, this non-compete law applies to them. So you might say, well, okay, that's it. That's great. That's for physicians. It's not for me as a dentist. What do I do about it now? Well, I'm giving it to you as an example of saying, look, this is happening. It's happening across the country. And, for those of you in Indiana, there will likely be a similar rule for you, as a dentist, but around the country, if you're not in a state that absolutely rejects it already, like California, you're going to see more and more of these rules come out. So if you're having trouble hiring associates, and the reason may be because your restrictions are too restrictive, then it might be a good idea to start to sort of change those, still protect your intellectual property, but not put things in place that limit their ability to compete against you, because as we just found out, these rules may get passed anyways. All right, now let's move on to lactation policies. There's a new federal rule called Pump for nursing mothers, which took effect, I should say, in April. The law at the federal level requires employers to provide a safe, it can't be a bathroom, right, but a safe place that's shielded from view and any intrusion. So that means like it should have a lock of some sort. If there's windows, shades from other coworkers or the public, where an employee can express breast milk. Okay, and this has to be you have to give reasonable break time for the employee to do this, and for at least a year after birth. Okay, after birth. So there's a lot of ambiguity. What is considered reasonable? Is it 15 minutes? Is it a half an hour? It just kind of depends on the mother and how much milk she's expressing. But the important thing is finding her a space to do it. Now, if you don't have a private office where she can use that, then some people are using private operatories, things of that nature. So just kind of think strategic of it. But we definitely don't want bathrooms don't count. Other public type places like lunch rooms where employees can come and go don't count. Unless you can lock that door so that nobody's coming in and going out, then that could be okay. But kind of keep this in mind. Now, this is the federal rule. As we talked about with minimum wage, a lot of states have their own rules, and so you just have to kind of counterbalance it and see which rule is more restrictive, and that's the rule that will apply to you. Okay. So if your state rule is more restrictive than this pump law that went into effect, then you go with your state. If the pump rules are more restrictive, then go with that. And if it's a mixture, then you got to figure out which is more restrictive and in each category and go with that. New York has their own lactation policy now, as effective June 7th, where they have to provide a location for nursing mothers that is close to the work area, is lit, is private. And, this is another example of what I was just mentioning, where these rules are going to continue sort of expanding. And so just kind of keep this in mind. It kind of goes without saying, but the New York law goes as far to say that, there must be a chair and a working surface, and even access to water or an electrical outlet. Now the water thing is a little bit difficult because if they're using your private office, there probably isn't, a sink in there. As long as there's one nearby, I think that's okay. But the electrical outlet is important, obviously, for the machines. Okay. All right. Now let's again stay on with this, with this topic of pregnancy and whatnot. The Pregnant Workers Fairness Act has gone into effect in June. It's a new law that covers employers to provide reasonable accommodation to a worker if they have a limitation that was related to their pregnancy or childbirth or whatnot. Okay. So now, it can't create undue hardship for the business, but undue hardship under the rules is a very high standard, right? I mean, it means that it would create such a hardship that you would go out of business or have to close the office down. I mean, something like that serious, some sort of inconvenience doesn't apply. So just kind of keep this in mind. Now, many states have these rules already, right? So it's nothing new for most of you, but the federal government is now, passing these rules and just making it even more relevant for you. Now, some states have these rules for, employers with employees with 25 or more employees or whatnot. The federal rule is 15 or more. So just kind of keep it in mind. What kind of accommodations are they thinking about? Well, sitting and drinking water, potentially having closer parking if that's available, more flexible hours, scrubs and other uniforms that maybe, have, different sizes available to them, maybe additional break time, additional time off, even for childbirth, recovery, and this might be, because of a C-section or whatnot, or it could be for other reasons like, post-childbirth issues, psychological or otherwise that could come up. And then if there are some sort of strenuous activities or lifting heavy boxes, things of that nature that they may be exposed to, those could also be potential accommodations for a time that you would have to put in place for them. Now, there's a lot more to this. We wrote a white paper on this topic. So, and there's a great poster that we have as well. If you want to download that, take a picture of this on your phones, this QR code. And if you put in your email, you'll get this, and you can read about it. You can post it in your lunchroom if you want, or you can just save it in your email for reference in the future. But it's a really, really great tool. So take a picture of that, and if you don't get a chance to, or something doesn't work, just let us know, and we'll repost that. All right. So what does this all come down to? Well, as you can see, keeping track of these leaves and whatnot is super, super important, because one, you need documentation to track it in terms of days and times that people are off in case something doesn't work out. But two, the obligation is on you to have all this record keeping. And so whether someone's taking time off for pregnancy or vacation or otherwise, the responsibility is on you to track that leave. And one of the reasons why Henry Schein and HR for Health have this, relationship together regarding HR is because so many of you raised your hand and asked for help in things like this, in terms of being able to keep track of this data, because you don't have it. And when, the issue comes up, if you don't have this, then it leaves you exposed. Okay. So what are the kinds of things and leaves that you need to be aware of? Well, Oregon, for example, has the Family and Medical Leave Act, and they have basically finalized this temporary rule where they weren't sure how to calculate the employer size, because depending on the size of your office will, how much you pay in terms of how much time you give in terms of family and medical leave, it's relevant. So the rule now specifies that in order to determine whether you as an employer are considered a small employer, or whether you're considered an employer that, needs to abide by this rule, you have to calculate the average size or average number of employees you've had over a 12-month period, right? Over a 12-month period. So this allows people to, or prevents people from sort of gaming the system a little bit. Again, it's really important to keep track of this and to have the data, the data, on the back end, so that if anybody ever challenges you on it, you have the information. For those of you that are in your first year and you need to abide by these family and medical leave rules, there's specific instructions for you. Okay, so just kind of keep that in mind. Colorado, also effective in March, required some changes because now their medical leave is based on the earnings of all the positions that were held during that relevant time, as opposed to just the earnings from that job that the employee had who was on leave. So again, hugely important from a data perspective, right? From a data perspective. So you need to have this. We keep track of all of that at HR for Health, so you don't have to. And you can easily do some calculations there. So again, this is a trend that we're seeing. Family leave laws are becoming, more robust around the country. And if you're not careful and on the lookout for these, it's going to come back and haunt you, especially because so many of them are now tied with data requests that they didn't have before. So this is sort of a quick slide of the trends that we're seeing in terms of across the different states. There are states that have policies that are already enacted. There are states that are, actively in the process of, putting legislation together. And then there are other states that are in the wings that we anticipate, occurring. And this is usually the case where, things start sort of in the outskirts and it starts to sort of expand around the country slowly. And you can see that from, the gray, which shows, the localities and other areas where these changes are starting to occur. All right. Okay. Let's shift gears now and talk about general state protection laws, sick leave, and some retirement things that are now law across the country. So a couple of quick things. For those of you in Arkansas, there's the Arkansas Civil Rights Act was amended to make sure that you are not discriminating on race, natural origin, ethnic, or racial, reasons because of someone's cultural hairstyles. So kind of keep that in mind. In Utah, they changed their protective order statute to allow employers to petition and obtain workplace violence protective orders against individuals who have engaged in or threatened potential violence. So if you have an employee who, has threatened it, even if it's offhand, it's super important that you keep an eye on this. And you can now get protective orders. We live in a super crazy society these days and things happen. So, don't take any of this for granted. Okay. In Georgia's voting leave law, we're approaching, another, year where there's going to be elections next year. So just kind of keep this in mind. It's important to have require time off to vote in person on a designated day, or for early voting, there can be that accommodation that's required if it's on a day before actual election day. And they have removed the waiver that waives voting leave requirements for employees who begin work more than 2 hours before the polls open, or leave work, more than 2 hours before the polls close. So there's been, again, a little bit more relaxation of this. We think, of course, as you know, the mess that happened in Georgia with the last election. I think they're trying to avoid, any complications as a result of that. And so these rules went into effect in July of this year. All right. So as you can see, a lot of changes are happening around the country. These will continue to happen because since COVID, there's been a huge focus on HR management and compliance. A lot of states are putting a lot of money, behind this to ensure that all of you are compliant, and they're not focusing on the larger companies anymore, although they're still focusing there. They're really going after small businesses, and of course, as dental practices, you are right there. So it's important to use our software for updated policies. You get an employment manual that's updated every year for you. So rely on us for the heavy lifting. That's what we're here for. And then that way you can have peace of mind knowing that you are safe, right? You are safe. Now, some sick leave laws that have changed in St. Paul, Minnesota, effective in February. They have changed their sick leave law, and now employers must allow accrual or use of sick leave and safe time when employees work within certain geographic boundaries of St. Paul. So again, kind of keep that in mind. There are rules that are changing with sick leave all across the country, and if your state doesn't have it, it doesn't mean that your county or city doesn't have it, as you can see from Pennsylvania's rules and other, small towns in Minnesota that are, having and enacting their own rules. Okay. All right. So now, in terms of retirement program deadlines, this is absolutely happening around the country. COVID shed a really important light on the fact that we as Americans don't have enough money saved, and as a result of that, the government has come in and has said that, look, we are going to force employees to retire and save money for retirement. And so what they've done is the states have passed a whole bunch of laws regarding this. And so almost, this is going to be in every state, or at least most states, soon, but a lot of the major states around the country have their own rules regarding, savings or whatnot. So please make sure that you are looking into that and that you have not ignored it. We still have employers in California, even though the rule passed 2 years ago, that don't do this. And now employees are upset that, they've lost out on monies that they could have grown in retirement, and it's causing litigation throughout the state. And so it's a big deal. It's a big deal. And it's not hard. It's not hard to do. We've got HR for out its own payroll system and 401k system that you can use, as part of the software. Both of them are incredibly priced, in the lowest of the low as compared to others. And the reason we do that is we pass on these costs to you, because for us, they're just commodities. We're, our major, sort of goal is to make sure you're HR compliant, which is where the software comes in. The payroll and 401k, applicant tracking, all these things are sort of add-ons. And so all the savings that we get, we just pass those on to you. And so it's great. And our 401k is the best in the business in terms of pricing. You can't beat it. So make sure you take a look at it. All right. Some other kind of security updates. South Dakota has some updates in terms of, the electronic delivery of health insurance information. As of July, you can now sort of get some of these documents electronically if you consent. Virginia has restricted use of social security numbers, where employers are not allowed to use social security numbers as the employee's identification number. This is actually, I'm surprised that Virginia took this long to put this into effect. This is a rule that's pretty common around the country, and has been the case in many states. And so Virginia now has that on there. And so if you have payroll checks and whatnot, you can't put the social security numbers on there anymore, pay stubs, all that. They all have to have sort of a unique identifying number. So it could be employee number 1, 2, 3, but just not their social security numbers. We're still talking about COVID. I really thought by now, we wouldn't be having any slides on this anymore, but we still, talk about it a little bit. There has been another surge of COVID cases or whatnot, but thankfully these rules, haven't necessarily changed. The good news is that in some states like California, they have implemented sort of non-emergency regulations for COVID as opposed to the emergency standard. And the good news is that these new rules around the country are less burdensome, right? They're less burdensome for the employers because one, they don't require you to do things like exclusion pay to employees if they're excluded from work during COVID. It eliminates requirements for you as an employer to pay for testing as well if someone has the symptoms of COVID. It allows you to have more lax outbreak procedures. If someone has COVID, it allows you to sort of align notifications and things that you would normally do with the old COVID rules. And so it gives a little bit more flexibility to employers, which is really great. But that being said, there are still, changes that are happening across the country. So if you want, to get more information about that, scan that QR code. Scan this QR code, and you will be able to, get more information about the changes across the country regarding the mandates and whatnot. Okay, and they're important. Like in Florida, for example, we had a doctor recently who was still requiring people to show proof of vaccination, but as of June, that now is prohibited. So those things that they burned into our psyche, a couple of years ago, has dramatically changed, and so it's important for you to know what those are. Okay, so check out that QR code if you'd like some more information on that. All right, so as we gotta get into the last section of our compliance for today, let's talk about what should you do for the rest of this year to set yourself up for compliance and also to be ready for 2024. We are expecting a slew of new rules to be passed going in, so the more you can do now, the easier things will be. The first thing is update your employment handbook with the new laws. If you still haven't updated it in 2023, please do that. But don't worry, you don't have to go to a law firm to do it. You don't have to go to your old, HR company to do it for you. HR for Health gives you one complimentary as part of your membership. And so just save that money, right? It's part of what, we provide as part of our relationship with Henry Schein, as they wanted to give you, extra goodies that you can use. And so take advantage of it. It's there as a Schein customer. Second is make sure you're looking at your new hire checklists, that you have all the documents for your employees. On average, you need anywhere from 12 to 20 documents per employee. So after you're done listening to this, if you go back to your office and you open up your drawers and you don't have 12 to 20 documents for each employee regarding, their hiring, then you absolutely need to stop immediately and contact HR for Health so you can get that and get going. That is the basis of compliance, right? That is the basis of compliance. Payroll companies will give you the basic stuff, the I-9s, the W-2s, maybe a state form here and there, but they're not giving you all that is required. And more importantly, they're not giving you the things that you as a dentist need in your office that are unique to you. Things like arbitration agreements and likeness releases, all of these things that are super important to a medical dental practice that payroll companies don't provide because they work with you and they also work with coffee shops and, bakery shops and cookie shops and all this kind of stuff. They're not thinking about this side of the business. And so make sure you do that. It's right there in front of you. Make sure the minimum wage in your states is updated, that you know what they are, and that if you've got people on the lower end of the spectrum in terms of compensation, that you are paying them at least minimum wage. And I know it sounds silly, but just do it. Your payroll company is not helping you. Okay. Make sure your employee certifications and verification and trainings are all done and up to date. Remember, it's a felony in many states to let a patient be touched by an employee who has an expired license. This includes a dentist. And so HR for Health tracks all of that, of course. But if you're not using our system, make sure you go through and make sure everyone's certifications are there. I can't tell you how many, RDAs, DAs, hygienists, don't renew their licenses on time, whether it's because they forget or the system is down or they don't have the money. It doesn't really matter why, but whatever the reason is, you're liable as the employer. So think about that for, as you kind of go through your checklist for the rest of the year. And then, of course, tracking your benefits and PTO, sick leave, all of these are super, super important. They should always be tied to your time clock system. So don't use the time clock in your, in your practice management system. That doesn't do the job. You want to use the time clock in HR for Health that is coordinated with all of these things. So as people clock in and clock out, it tracks their PTO, their sick leave, their benefits. It tracks it all, right? So hugely, hugely important, and super easy. So that somebody wants to go on vacation, they just put a request in through the system because they know how many hours they have and so on and so forth. Super easy. Now, how do we help at HR for Health? Well, the better question is, how do we not help, quite honestly? Because I created this software with the thought of making sure that from A to Z, you are HR compliant, right? As a dental lawyer, I have seen so many lawsuits in this area. It pains me that this is still happening, but it is a super, super easy process for you to get compliant as long as you're following our metrics, right? It starts with the handbook, which we do for you, customized every year, no problem. We handle your payroll if you wish. If you want to stay with your payroll company, fine. If you want to come with us, fine. But you have to be with us on HR compliance. If you're on HR for Health for compliance, I'm less worried about you using somebody else's payroll. But if you're not with us on HR compliance and you're using somebody's payroll, then you have high risk. We have total HR support. What that means is that you pick up the phone, send an email, chat with our team, our experienced HR professionals that will coach you through any HR issue. If you cannot, or if they cannot help you, because let's say it's a legal question and you must talk to an attorney, they will transfer you to either my law firm or another friendly law firm around the country who will consult with you for free as part of your membership. Now, if you get sued, God forbid, there will be legal fees. You'll get discounts and stuff, but there will be costs. But the consults and whatnot are all included as part of your membership. It's the best way of making sure you're protected. All of the documentation is there for you. Of course, we have performance reviews, violation tracking, all that stuff is there in the system. It cannot be destroyed, cannot be deleted by anyone. You have total access to it. If your HR person changes, and you bring a new office manager or whatnot, that data is still there. So you don't have to worry about somebody learning something new. Great tool. And it's a great way of protecting yourself. Documentation is the secret sauce to compliance. Okay. Time clock, as I mentioned, we have the best time clock in the entire country in when it comes to dentistry. It is tied to every aspect of their employment, benefits, PTO, vacation, all of it. So use our time clock. It's IP specific as well. So unlike other systems, they can't clock in anywhere else, right? They have to be in the office to clock in and clock out. So hugely advantageous. And then finally, in order to grow your employees, we have annual reviews, performance reviews and other things that you can use. All right. So take advantage of this, schedule a demo, with HR for Health. See if it's a good fit for your office. Our team will run through it with you, no pressure. See if it's a good fit. If it is, great. We'd love to have you in the family. If it's not, we'll still coach you, and make sure you don't get into trouble. But I can guarantee you thousands and thousands of doctors nationwide are using HR for Health for compliance. And we've teamed up with Henry Schein to make sure you all have access to this. So I hope you take advantage of it. And thank you guys very much. And that's it for me today. Josh, you want to take it from here?
Sure. Yeah, great. Thank you for that great presentation, Ali. And I want to thank everyone for joining us tonight as well. And just so you know, we did also record tonight's webinar, and we will be emailing out the recording sometime next week. We also would appreciate your feedback via our survey that will pop up on your screen after you view the webinar. And I would like to thank you all for joining us. And of course, we look forward to seeing you all on future webinars as well. Thank you, Ali.
Thank you. Bye, everyone.